Dear students, once again we have to meet to discuss about the applications of biotechnology. I am repeating once again only for pure science students, not for bio students. Now yesterday we were talking about biosafety guidelines. Under the biosafety guidelines, once again we have to proceed about intellectual property rights and intellectual property protection. Intellectual property rights, that is called IPR. Another one, intellectual property protection, IPP. Okay, these are the two aspects we have to discuss under the what we have biosafety guidelines. Now we have some physical properties. That's the physical objects in the form of, you see that one, household goods or lands or other properties. And also we have the ownership and some properties. So all these ownership and properties are protected by certain laws available in the country. So this is called physical intellectual property, or we can say physical property. This physical property, it's not intellectual property, simply physical property. Intellectual means, what do you mean by intellect? A person thinking, reasoning, knowing and explaining and find out a new thing, inventor or discoverer. We are calling these people intellects or intellectuals, using the mind, discovering or inventing new things. So any new thing that has been made by a person being protected by means of intellectual property rights or by means of intellectual property protection. So far I given only the physical property. Such physical properties are tangible. Such physical properties are tangible. The meaning for that one, it is shakeable, it is breakable, it is changeable. Either the land or house, anything else. Suppose you are holding that property now, it may be just broken, you are losing the house. That is called, it is tangible, that is shakeable or changeable. But we have transformed microorganisms, animals and plants. Also we have technologies for the production of commercial products or exclusively the property of intellectuals only. So the transformed microorganisms, for example, Pseudomonas fetida, a genetically engineered organism, the first one, a bacteria, made by a person, Indian-born American. Okay, so people use the transformed microorganisms, otherwise we can say genetically modified organism, GMOs, that is animals, plants, and the technologies what we use through biotechnology for the production of commercial what we have products. These commercial products which are being made through GMOs are exclusively the property of intellectuals, the one who has made it, the one who discovered, the one who invented. So that is the right of that person who hold actually the rights, copyrights or patents, etc. discuss. So the inventor or discoverer has complete rights on his property or invention. No one can actually just claim it. So the inventor or discoverer has complete rights on his property or invention. This is not a physical property, it is an intellectual property. A new thing has been invented, a new thing has been discovered by people, and such people are called intellectuals, and we have to provide protection for them. There are certain rules framed by the government to protect the intellectuals. The rights of intellectuals are protected by laws framed by a country. Suppose a person has produced a new basmati rice. That belongs to him only, he is the owner of that one, the right. That is what we have, the intellectuals have the right to claim that one, hold that one. If he wants, he can just provide for others to use it. So normally it is being defined for certain years. It is not a permanent one, what we have the legal rights. It is a temporary one. We will discuss later about that one. It may be confined to certain years, say an example of 20 years, patency, etc. So we will see about that is intellectual property protection and also the rights one by one. The intellectual property, we talked about the physical property. The physical property is intangible, changeable, breakable, touchable. But you see that when the intellectual property is an intangible asset, it cannot be changed, it cannot be broken. Once a person has invented a new thing that belongs to him only, no one claim it. That is called intangible asset. Now we have the legal rights or the patents provided by the government or anybody else in the form of laws. So the legal rights or patents provide an inventor what is called a temporary monopoly. Only a temporary monopoly means monopoly belongs to that person, only one person, for the use of invention. So temporary monopoly means the invention is used by actually that person who has invented, the inventor, for a defined period of nearly 20 years. He cannot claim beyond that level. So it is only temporary monopoly. Though it belongs to him, one person, that's a monopoly, it's only temporary, for only a defined period, not beyond that level. That's why it's called as temporary monopoly. For the use of invention, what he invented, he can use it only for a short period of about 20 years. That is normally generated by the government. So, while they have a temporary monopoly, they have the right, that is disclosing the knowledge to the others. They have the right to disclose the knowledge to others. The one who may use the knowledge, what for? To develop further invention and innovations. Though he has only temporary monopoly for the use of that what is called invention, he has a right to disclose or open the knowledge of such one, the invention, to others. Just that person may use, that person may use, the one who receive, for further development in what is called innovations, or we have, for example, invention. To develop further inventions and innovations, it may be disclosed that person. Okay, though he is having a monopoly, he can just show that one, opens that knowledge to others too, for further development. Now we have laws made to protect what we call the individual or intellectual property rights. These laws are made at the national and international level. The laws are made or formulated just at the national and international level. It is not a constant one. From time to time it is being changed. The laws are being changed from time to time. So the formulations occur time to time. Now, development of new plant varieties is also an example for intellectual property rights. When a person is generating a new plant variety, it is also an example for intellectual property rights. So there is nothing but plant varieties developing. When new plant varieties are developed by a person, it also considered as intellectual property rights. But this one, the development of new variety of plant, is protected by another agent, what is called plant breeders' rights. Plant breeders' rights. The plant breeders' rights also generated by the government. The plant breeders' rights normally look after the new plant varieties which are generated. So it is being protected by PBR, plant breeders' right. Now let's go further a few words about the plant breeders' rights or PBRs. The new variety of plant that is developed is protected by PBR, plant breeders' rights. Now these plant breeders' rights recognize the fact that the farmers and what we call the rural communities, they have contributed what for? The creation, conservation, exchange and knowledge of genetic and species utilization. So these people are so while considering, while giving protection to the new variety of plants, now this PBR, the PBR plant breeders' right have to just recognize the various facts regarding what we call the creation, conservation, exchange and knowledge of genetic and species species utilization. Knowledge of just actually genetic and species utilization of genetic diversity contributed by the farmers and also the rural communities. These are all actually the facts being considered by the PBR, plant breeders' rights. Now we have just we see that one, intellectual property rights and intellectual property protection. These are normally granted by the government to the plant breeders if one wants to develop a new variety. So they were granted by what is called the government to the plant breeders. What for? To develop a specific plant variety. That plant variety is new, not an old one, similar to the old varieties, new and never existed before. Then only they are granting what we have just IPR and IPP to the plant breeders. That is intellectual property rights, intellectual property protection. These are granted by the government to the plant breeders. What for? To develop a new specific plant variety. That variety should be new and also it never existed before. That's about the rule framed by the government just regarding IPR and IPP to the plant breeders. Now let's see the protection of IPR. Now the IPR or intellectual property rights is protected by different ways. What are the different ways of protecting IPR? Number one, patents. We'll discuss. Number two, copyright. And number three, trademark. These are the three ways by which we can protect what we call the new inventions or we have, that is IPR, intellectual property rights. Now first one, patents. Now you see that when the science of biotechnology involves the production of enormous number of commercial products of economic importance. Okay, so we are inventing different things. Now normally the invention includes 1. Biotechnological products and 2. Biotechnological processes. Now let's see what are the biotechnological products. These include the living units or the living entities like the microorganisms, the plants, the animals. Then we have also, you see that one, cell lines for continuity, cell organelles, plasmid and gene, along with naturally occurring substances like primary and secondary metabolites produced by the living system. Primary metabolite, the product of an organism, is useful to that organism. Secondary metabolite is a product of one organism is useful to some other organism. For example, we have the secondary metabolite in the form of alcohol produced by Saccharomyces cerevisiae, the yeast, Baker's yeast. Another one what we have also, antibiotics. So antibiotics produced by a particular organism and that will be harmful to or detrimental to another organism. But it's not used by the possessor. That's called secondary metabolite. Useful to some other organisms, not to the possessor. So the biotechnological products also include the naturally occurring substances, mainly the primary and secondary metabolites produced by the living system, example alcohol, antibiotics. And right on the board we'll continue further about what is a patent. And another one, what are biotechnological processes. The field of biotechnology involves number one, the products, another one, the processes. Now let's see what are the biotechnological processes. We already discussed once again here. So the processes involve number one, isolation. Number two, the purification of the product. Number three, the cultivation. And number four, bioconversion of novel. What do you mean by novel? A new, just best. A new and best. So novel, innovative, simple, cost-effective processes. Innovative, creativity, cost-effective processes, and creation of biotechnology products. So that's what we have biotechnological processes, the events. Now we are studying about patents. What is the definition of patent? A patent is nothing but government issued document. It is a government issued document that allows the person exclusive right. It allows a person for an exclusive right to manufacture, to use or sell an invention in a defined period. I mentioned already monopoly, temporary monopoly only. They can have only for a defined period. Generally the period is about 20 years. He can hold it for a period of 20 years. Now it is a legal document for safeguarding what we call the rights and privileges of inventor or invention. So it is nothing but what is called a legal document because it is being provided by the government. That is safeguarding the rights and privileges of inventor and invention. Now what is the purpose of patenting? Let's see now. So the purpose of patenting in biotechnology. What is the main purpose of patenting? To ensure fair financial returns to those who have invested finances, the ideas, the time and hard work for invention. That's the main purpose. The person who has invented something should be rewarded in the form of payment, royalty. Now, what are the criteria that must be satisfied in patenting? We have to follow certain criteria while patenting. Now, first one, the invention must be novel and useful. Novel I mentioned, best and new, and useful to the people. The second one, the product must be inventive and reproducible. A new one, invented new one. The reproducible means we can produce more and more copies of that one. The next one, we have the patent application. While just describing something about what we have, the invention, we have to fill up the application. So the patent application, that should be provided, or that should provide full description of the invention. You have to provide a full description of the invention. This is one. While just providing an application, we have to provide a full description of the invention. And the invention must be what is called patentable. That should be patentable, giving just actually a person right to manufacture or use or sell invention. That is, invention must be patentable by the person who has invented that product. So this is about what we call the first way we can protect IPR, intellectual property rights. We have to go for other two things. And before that we also have to know another one, general agreement in what is called tariffs and trades, a paragraph. The first living organism that was patented was a genetically engineered strain of bacteria called Pseudomonas putida in 1980 by an Indian-born American by name that is Ananda Mohan Chakrabarty in 1971 to remove the hydrocarbons in oil spills. That's a role played by that one, that's what is called Pseudomonas putida, developed by Ananda Mohan Chakrabarty in 1971. But it was patented only in 1980. Now, another one, what is called GATT. That is nothing but the general agreement of tariffs and trade. And trade-related IPR is what is called TRIPS. A few words about TRIPS. Now, this GATT was framed in 1948 by what we call the developed countries. What for? To settle certain disputes among the countries. What for? Regarding their share of world trade. Sharing the world trade, that is what is called the business without dispute, and that was framed. Now, the benefits normally enjoyed by the developed countries, not developing countries. Now, in 1988, the US Congress enacted a law, and the name of the law, the Omnibus Trade Competitiveness Act, that is simply called OTCA, the Omnibus Trade Competitiveness Act, which gave power to the US to just investigate what we have the laws related to the trade. So that was an act proposed by US Congress, and power was given by US to investigate the different laws related to trade. Okay, that's about what we have. General Agreement of Tariffs and Trade, GATT, and also trade related intellectual property rights, that is TRIPS. Okay, we have to go for the next one, GI. What is GI? Then we have to go for copyright and then trademark. That's the last part. What is geographical identification? It is a name or sign used on products, normally corresponding to a specific region that possesses qualities or a reputation that are due to that region. So we are giving a specific, that one name even for a specific college from that one a person has actually studied. Like that, according to the region from where it has been just generated, we are giving importance based on the reputation, based on what is called the qualities that are due to that region, from that region only. We have some examples. Now normally we are using this geographical indication or GI for agricultural, that is products or food products or handicrafts and industrial products. Now we have the Darjeeling tea. That was the first GI tagged, what is called the product of India in 2004-2005. When I say Darjeeling tea, normally people just normally giving even more money for that one because its quality and reputation, it is very just tasty, and that is derived from the area, the region Darjeeling. So that is why we are giving what is called, that is GI tagged condition of the product of India, first one. If you are taking some more examples in Tamil Nadu, for example, Kanjipuram is known for silk. Coimbatore is known for, that one where grinders. Tanjavur is known for paintings. Madurai is known for malli. And also we have, you see, the jewellery of Nagarkoil or GI tagged products. So these are all the regions. When I am saying about Kanjipuram silk, people are, that one just attracted towards that one. The quality is good. That region, so it has been derived from a region of reputation and qualities. That is called geographical indication. People are attracted towards the area from where it has been collected. Accordingly, the money value, the cost of the product is also high. That's about geographical identification. Now we have to go for the copyright, a paragraph, and then a paragraph of trademark. The second way of protecting intellectual property rights is by copyright. What is that one? The protection of authorship of published work. Once a work has been published, it is not being taken by anybody. So that protection is copyright. Once copyright is given, we cannot take that one. So the protection of authorship, particularly the person who has published, or published work, comes under copyright of IPRs, intellectual property rights. Now copyright protection is given mainly for form expression of ideas. For form expression of ideas. For form expression of ideas. The ideas are being expressed naturally. To protect that one, copyright is needed. For example, the author of a book, the editor of a book, the publisher of a book, or both the publisher and editor of a book, they have the copyrights. These persons who made the book have copyrights. Now the content of the book cannot be reproduced. Once a book is given, you can make a Xerox copy it. We cannot what is called reproduce it, changing the order, changing the contents, etc. So the content of the book cannot be reproduced or reprinted, adding, just removing, etc. Without the written permission of what we have, the copyright holders. We have to get approval from the copyright holders, then only you can touch that book. We can just reprint it or we can just actually reproduce it. Now we have normally comparison between the patents, trade secrets and copyright. We are going to have, that is also the trademark next one. So patents and trade secrets provide protection for the basic know-how. It gives protection only the basic principles. the basic know-how. And while copyright protect the expressed materials, the materials are in printed form or video recorded, or we have, for example, just a taped one, etc. So this is the difference between what we have the trade and patents in relation to what we have the copyright. Now, in the field of biotechnology, for example, the database of DNA sequences, any published forms, or photomicrograph are subject to copyright. The photomicrograph, the DNA database, any published form, all are normally under what is called copyright. We cannot touch that one without the permission of the copyright holders. That's about the copyright. We have to go for one more, what's called the trademark. So each and every product has its own symbol or name that is actually called as a trademark for that one. For example, TTD, Perumbay, that's what we can say. There is what is called the trade name, or Fanta, the trade name. That is what we have other drinks like that, Vento. All are trademarks, just identifying a particular product from that company, and that is called as a trademark. A name is given or a symbol is given that refers to what's called the trademark. We'll have just a few lines about it. What are the other products subject to that is copyright in biotechnology? In biotechnology, the database of DNA, this is number one. Database of DNA sequences, any published form, either just what we have in the form of book or in the form of what is called video record, or we have in the form of any other form. Photomicrograph, just with the slide preparations, are subject to copyright. These are the others which are subject to copyright. The last one to protect IPR, the trademark. What is trademark? Any specific symbol or words to identify the product or a process of a company constitute, that is what we have a trademark. So for each product you have a trademark or a symbol or a name or a word, and that is called what is known as actually the trademark. What for? To enable the people to distinguish differences or distinguish between the traders' goods, the original goods, from the similar goods of what is called other traders. We have just actually trademark varieties. We have also duplicated varieties similar to that one to differentiate the goods of other traders from that what we have, that is traders, good traders with a trademark, and that is for trademark. So it enables the public to distinguish traders' goods, the original traders' goods, from similar goods of other traders. So this is about the last one to what we have to protect IPR, intellectual property rights. One, the patent, the second one copyright, the third one trademark. Okay, so I want to give two more notes. What is biopiracy? What is what's called bioethics? The next one, biopiracy, it is nothing but taking away one's material without his knowledge. Generally we can say pirates. The pirates are the thieves of the sea. Likewise, they are taking away the material without one's knowledge. So here we are concerned with the bioresources. Now it is defined as a use of what is called bioresources by multinational companies and other organizations without proper authorization from the countries and the people concerned. Okay, even without just providing payment, compensated payment was not given. That is called biopiracy, taking away one's invention or discovery of the products without his knowledge, without his proper authorization, even without paying what is called the compensatory payment. That is called biopiracy. It is nowadays very common, taking away the material, telling that one, I have invented this one. Like that people are saying. This is called biopiracy. So the next one, bioethics. Because of the advancement in medical field and what we have biology, people are nowadays just actually not obeying the disciplines of moral values. So they have created something different away from the moral values, the natural moral values. Ethics means the moral values. So bioethics, it is a study of ethical issues emerging from advances in medicine and biology. Now these ethical principles, the bioethics, what we are talking about, people are not concerning about the moral principles. So bioethics also a moral discernment, a good judgment. Moral discernment means a judgment, a good judgment. So moral discernment, a good judgment as it relates to medical policy and practices. So normally the ethical principles are nowadays related to what we call the medicine, the medical policy and the practices of medicine. So that is what we call the bioethics. Even for example, people are just having infanticide through some sort of methods. If there is a female child developing, so it is away from nature. With this I completed the chapter Applications of Biotechnology both for bio students and pure science students. We have to pass on to the next lesson, that is chapter 2, Reproduction in Human Beings. I'll take it in the next class. Okay, study all these things, study properly because it is a long lesson, just like molecular basis of inheritance. Study well and prepare well, go through the what is called the videos. Thank you. I'll meet you once again in the next class.